Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Hello and welcome to Navigating Consumer and Family Law Challenges, insights from SoCal's trusted attorneys with Sara Khosroabadi. With a focus on consumer protection, Sara offers helpful, caring, and professional legal services and advice. I am your host, Kevin Rosenquist, and today we're going to discuss the Fair Debt Collection Practices Act, a lifeline for consumers. Sara, good to see you.
Hi, Kevin. How you doing?
I'm doing well. I'm excited to talk about this because no one likes getting harassed by creditors. So at what point in the timeline does creditor harassment usually begin? And what methods do they typically use to reach debtors?
It depends. So there's two different forms of creditor harassment that I like to think of. One is from the actual original creditor. So let's say Chase Bank or Wells Fargo, and you owe a credit card, for instance, or on a loan, and their collection department in-house tries to collect from you. That could be something that definitely can get a little bit harassing and or, repetitive at times. And then what ends up happening is at some point, Chase or Wells Fargo, they realize they're not going to be able to collect on this debt anymore. So they do one of two things. They either send it to they charge it off. It's called a charge off. And they either send it to a debt collection company, like we have a few out here that collect in California, Midland, Portfolio Recovery Associates, LVNV, for instance, and they'll sell it to those companies. And then those companies then try to collect that debt on their own behalf, right? Or what ends up happening is Chase, Wells Fargo, they'll actually give that file to an attorney, a law firm out here, and then that law firm will collect on that debt and or file a lawsuit. So it depends on, where they're at. But usually it's once you stopped paying on that credit card, you're looking at maybe a couple months. In the past, I've seen it go a couple years before it gets to that point. Most recently, I've seen it as few, as 3 or 4 months before it gets to the point where it's in the court system.
So for the collections agencies, so do they buy the debt at like a discounted price and then they try to collect the full amount? Is that sort of how that works?
So I can't say 100% that is, I haven't seen a contract on that, but mostly because they won't give it to us. Yes, that's the general idea, is that they purchase these debts for pennies on the dollar and then they essentially collect on it. So we do definitely see these debt collectors buy big bulks of debt, $1 million worth of debt in one transaction for not $1 million. So,
for not $1 million, yeah.
Not $1 million, yeah.
Otherwise, I'd question the business model. So I guess it makes sense.
Yeah, exactly.
So let's talk about the FDCPA, or the Fair Debt Collection Practices Act. Can you explain what that is and how it regulates debt collection practices?
Yeah, absolutely. So there's a federal statute called the Fair Debt Collection Practices Act. And what it does is it protects consumers from harassment regarding these debts. So for instance, debt collectors can't contact family members or neighbors or your work and tell them about your debt. It's supposed to be confidential. They can't send you anything in the mail that says you are a deadbeat or you owe money on the outside of that letter. So a lot of things that you don't realize that debt collectors don't do is because they can't, pursuant to the statute, right? They can't tell, like I said, they can't tell your family. They can't contact you after 9 o'clock at night or 8 o'clock in the morning. So you don't get those harassing calls during those times. Also, they can't contact you multiple times a day, especially if you've spoken with them and let's say you talk to them in the morning, they can't then continue to call you to harass you for that money. So those are important portions of the statute. There is a California equivalent too. It's the Rosenthal Fair Debt Collection Practices Act. And that one's mainly geared towards original creditors. So that means Chase, Wells Fargo, Bank of America, those companies, there's a statute that protects California consumers against harassment with that. The Fair Debt Collection Practices Act is only for debt collection companies and for law firms that collect debt as well. So California went a step above and tried to protect consumers from the original creditors as well.
Don't know if you know the history, but was it just getting out of hand? Is that why this happened? I mean, were creditors just like banging down doors and calling friends and family, and is that what happened?
Yeah. So essentially what ended up happening, just like any other law that's out there to protect, just people in general, population in general, was that it was getting a little out of hand and they just needed some protections in place. So for instance, we do it a lot with regulatory statutes, right? Like overdraft fees or interest rates. Once they get usurious or they become too high, then the government kind of steps in and says that's not okay. So that's essentially what happened with the Fair Debt Collection Practices Act as well.
Who is protected under the FDCPA, and what types of debt are covered by the act?
Good question. Consumers, it does have to be a consumer debt for the Fair Debt Collection Practices Act. So for instance, it has to be for the primary purpose of your everyday needs. So grocery shopping, anything that you do for your personal household. If it is a business debt, it is not protected under the Fair Debt Collection Practices Act. And then the type of debt, it could be any debt. It could be any, credit cards, loans, even mortgages sometimes are also covered under that as well. And then it also lends to its agents too. So for instance, if a law firm is collecting on behalf of their client, you actually can sue the law firm and the client at the same time because the law firm is acting as an agent for the client. California most recently has looked to actually include business debt too. So that'll be interesting to see how that affects everything. Because right now, business debt collectors, they kind of get a free pass and a free ride. They don't have to do much to worry about following the guidelines of the Fair Debt Collection Practices Act and the Rosenthal Fair Debt Collection Practices Act. So we'll see.
So there's a sense that that's going to start to be part of the business that's going to fall into that as well soon?
At least under California law.
Yeah.
So under the California statute, maybe not so much under the Fair Debt Collection Practices, but under the California statute, it seems like it's going in that direction.
All right. So you mentioned certain hours, certain things you can't put on the outside of an envelope. What other actions are prohibited under the law, and how else does the FDCPA help consumers?
A couple things that I've seen that were pretty egregious were name calling. It was pretty bad. Racial slurs, voice messages left with racial slurs, telling people that they're deadbeats, that they can't afford their debts. I've also seen in my career, I've seen issues with people telling them that they're going to go to jail. Debtor's jail hasn't been a thing in a very long time, but telling them that they're going to go to jail. Or one I see often that gets a lot of people scared is just the threat of being sued. So in California specifically, there's a 4-year statute of limitations on for how long a debt collector or an original creditor can file a lawsuit. So once you're outside that 4 years, you can't file that lawsuit anymore unless somebody makes a payment or makes a promise to make a payment on that debt. So oftentimes what debt collectors will do, the really scummy ones, they'll say, oh, we're going to file a lawsuit against you, but it's been 5 years since that person has made a payment on the debt. And they not knowingly, then they'll say, just give us $5 as a, to protect you and as a good faith offer, and we won't file that lawsuit. Well, then you now pay that $5 and the statute of limitations starts all over again. So I have seen that, not most recently, but I have seen that in my career. And then also, I think a lot of times we get people who contact work or they contact family members, and they'll say things like, get your deadbeat child to pay their debt, or, they'll just even doesn't even have to be that bad, even disclosing the fact that, they owe a debt, they haven't paid that debt, and that they need to pay it is just as bad as everything else I've said under the law.
Wow. That's crazy to me. I mean, I guess I shouldn't be that surprised because, and you're right, it's not to say all debt collectors are like this. That's the majority of them are probably have a little more, maturity to handle things than that. But wow, racial slurs and name calling and name calling to other people about you.
Yep.
Wow.
Yep.
All right. Well, I guess this is necessary then. So let's talk about if a debt collector violates the FDCPA or the California specific one. I'm sorry, I forgot what that one was called.
It's the Rosenthal Fair Debt Collection.
Rosenthal Fair Debt. Yes, it's close to my last name. I should probably know that.
Yeah, that's why. I don't know why it's called that, but
so if the collectors violate those, what happens?
So typically we can file lawsuits on behalf of the consumer. So we would end up filing a lawsuit, and then if we do prevail, then the consumer can actually get their attorney's fees paid for that violation. And it depends on what's going on, but the violation itself, it's a statutory violation, which means just by sending out that letter with the wrong information, I know I didn't go over that violation, but there's specific language that has to go on a letter. So if that language isn't on that letter, and you potentially can file that lawsuit just based off of that. And each lawsuit is essentially up to $1,000. And then you can get your attorney's fees and costs paid on top of that. And then any emotional distress that you've got going on too. So a lot of times with collection, it's not just a one-time phone call that happens. It's multiple phone calls. People are staying up at night. They're stressed about this. They feel like there's no hope. They don't know what to do. And then you've got a debt collector who just won't stop contacting you about this debt. So oftentimes that leads to the emotional aspect of it. And we can sometimes recover monies for that too.
So is the maximum, the statutory fine of $1,000, is that no matter what the infraction? Like if it's leaving something out of the letter versus calling somebody a scumbag, deadbeat, blah, blah, blah?
So it's up to $1,000. It's not necessary. That's just the statutory portion of it. So then that's where it comes into play as far as like the emotional distress. So if it is just a letter, then maybe you are looking at $1,000 or up to $1,000 for that amount for settlement. But if you do have the racial slurs and the contacting family members and the embarrassment, then that's when you can bring in the emotional distress as well.
How often have you seen it go to that point of like legitimate name calling, harassment, et cetera?
Earlier in my career, I saw a lot of those calls. It sometimes is smaller companies because they don't, it's not the Chase and the Wells Fargo, although it can be, but you typically don't see that because they've got the handbooks and they've got the training. But sometimes you'll see smaller companies that are trying to collect for themselves and they don't know the law. They don't know what's going on. And then they end up using, these tactics that don't work because they're frustrated themselves because they're not receiving their money, but they take it too far. So I've seen it happen, not as much recently, but I have definitely seen those cases where it's been pretty bad. I do have a couple of cases where they've contacted the office, they've contacted their work, and they've not necessarily said what the debt was, but they have alluded that somebody owes debt. And that can get really tricky for consumers because they're like worried about their boss finding out or they're worried about colleagues finding out. And again, that leads to a lot of embarrassment. So the more egregious ones are few and far between, but they definitely do happen.
Yeah, and you never know what someone's going through. Like to call someone a deadbeat, you don't know what their life is like or what kind of issues they might have, whether it's medical issues or losing a job or whatever. Just to call up and start firing insults is, I don't know. That blows my mind. I did not realize that. I mean, I guess again, I shouldn't be so super surprised. I see how people talk to each other on social media, so I don't know that I should be surprised. But yeah, what other protections do you think will come from debtor harassment? Do you think that it'll expand? The protections will expand in the near future?
So we're definitely seeing that with California, right? So it's been consumer debt for the longest. And now that they're turning it to also business debt, I think that that's going to be a huge change in California's industry, at least, because, right off the bat, if I was talking to a client and trying to figure out if I could help them, first question is, what did you use the card for? What was the debt for? So the consumer side of it, needing that to the business side, I think that's going to be huge. There are a lot of debt collectors out there that do collect on private loans or they collect on smaller loans and they do file lawsuits against businesses as well. And there's no protection for those businesses or for that consumer. So oftentimes what I see is, for instance, a credit card company will sue the business and they'll sue the owner, and because the owner is a guarantor, right? So they'll sue both of them and then they'll harass the owner. The owner has no protections because it's a business debt. So I am excited to see what this does for the industry and see if maybe that'll relax how the commercial business collection does what they do.
Yeah, especially because you have a lot of mom and pops and one person operations and stuff that so you don't have that protection of the business separate entity kind of a thing, at least not in the surface, I suppose.
Yeah, exactly.
Finally, can you share any advice for people who feel overwhelmed by debt collection calls and might need some help understanding their legal protections or just options?
You have a right to say, I want everything in writing. You have a right to say, I don't want you actually contacting me. Please stop contacting me. Oftentimes when clients hire us, we tell them, let them know you have an attorney and just let us speak with them so that you don't have to deal with the emotional toll of them collecting from you. So you definitely can tell them to stop contacting you. The Fair Debt Collection Practices Act, it went through a change in 2020, where it added this nuanced layer where people could actually contact you through social media. Like you couldn't contact through social media before and you couldn't contact through email before, but because things have changed and because our methods of communication have changed. The laws have allowed collection agencies to start to use those means of communication. So I think it's even more important, especially on social media, especially through email, that you do let the debt collectors know that you don't want to be, contacted in that way, and that you're going to assert your rights under the Fair Debt Collection Practices Act or under Rosenthal. But I think something that they definitely can do is, if they're worried that maybe it's not harassment or they don't know, contacting a consumer protection attorney just to figure out what their rights are, what they can do with the debt. And then also sometimes it's just a matter of, if they do file that, or they are trying to collect from you and they do it in the wrong way, then you have some recourse. You can file your lawsuit. And I'm not saying that you can necessarily get rid of the debt, but you potentially can get paid, and then you use those funds to pay off the debt, right? So there are some upsides to being able to make sure that you are asserting your rights.
Is there any value in name dropping the FDCPA if somebody calls? Will that scare them, or are they just like, whatever?
It's hit or miss. I think from what I've seen, there's a lot of turnover in the debt collection world.
Yeah, it doesn't seem like a real desirable job. So I'm not surprised that there's a lot of turnover.
It really isn't. And I think they try, to train, but it's hard to train on these violations. And I think if you do you definitely could use the Fair Debt Collection Practices Act to say that you know what your rights are and you can assert those. I don't know if it would make a difference for that debt collector. If they're going to harass you or they're going to be mean-spirited, I think they're going to do it no matter what you say.
They know it's there. They're not going to get scared.
Yeah, exactly.
That makes sense. All right. Well, thank you for joining us on Navigating Consumer and Family Law Challenges, Insights from SoCal's Trusted Attorneys with Sara Khosroabadi. To connect with her firm, visit kandhlawgroup.com. And please like and subscribe to our channel. We love having you be a part of our community. Sara, always good having you here. Thanks so much for your time.
Same. Thanks so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.